Hello, Mrs. Vives.
Thank you. Mr. Stevenson?
Good morning, Your Honors. My name is Charles Stevenson. I represent the defendant, Alberto Vives. This is a distressing case, but not a particularly complicated one. Mr. Vives was convicted of felony murder, the underlying felony having been an armed robbery. Unlike the two prior cases Your Honors have considered today, identity simply was not an issue. The only real issue was Mr. Vives' state of mind on the day that the offense was committed. This is a young man, 18 years old, who, according to one of the two key Commonwealth witnesses, was a respectable young man. According to the other most important witness, was a beautiful person. On the other hand, as Your Honors know from reviewing the papers, for the 4 to 5 days immediately prior to this incident, there were other incidents, all in this apartment building where Mr. Vives lived, and in fact within steps of the doorway to his apartment, room 202. All of which suggests, and certainly it would have been appealing to come before the court and bang on the desk and talk about joinder and how unjust it was in this case. But in fact, the judge's ruling that all of that evidence would have been admissible was completely correct, and therefore, while it made the case very difficult to defend, it was an appropriate ruling to join the various charges which stemmed from, I believe it was May 28th, June 1st, and then ultimately the homicide which occurred on June 2nd. Really, the primary, if not the only issue before the court today is the question of the sufficiency of the judge's instruction on the question of a reasonable and honest belief that Mr. Vives was collecting on a debt that the victim, Ricardo Torres, owed him. There had been discussion.
Even if he were, what do you do about the fact that it was an illegal one?
Well, that certainly is an issue, and of course,
So why do we have to bother with whether we're a debt or not, since it can't be an illegal debt, and a debt for the sale of narcotics is illegal?
I guess my first observation is that point was never made to the trial judge, who concluded that the instruction was one that was warranted.
Okay, but it's so obvious it doesn't really have to be made.
Well, I would suggest that's absolutely not the case, that in fact the evidence was, there was about a paragraph of Mr. Vives' statement to the police. It was the third phase of the interrogation, in which he made reference to Mr. Torres and the events outside his apartment that day. And what he said was, I knew this guy. This guy owed me money. I knew him because he dealt for me at some point. And I can't be, without pulling out the actual statement, but it is quoted at some point in my brief. It's not at all clear, I would suggest, Your Honor, very much so, that this was an illegal debt, that it was a debt related to drug dealing, other than the fact, of course, that we have this defendant.
Well, please, counsel, being objective, wouldn't you agree that this was a drug den, like a crack house we're talking about, that everybody in the house was involved with drugs?
No,
just about everyone, and that on that May date and earlier in June, he had been in a drug-induced state, and that he was ripping people off so that he could continue that drug-induced state. We can agree on that?
We absolutely can agree on that. We can also agree on the fact that Mr. Torres was there hoping, within the building, hoping to get some drugs. His friend had described him as being drug sick, and the coroner found that, in addition, he was intoxicated, legally intoxicated. But although there are no pictures before the court right now, it's a large apartment block in Holyoke, and a section they refer to as the Flats. But it's 4 stories tall. There are, my impression from the testimony and from driving by is that there are perhaps 20 or 30 apartments in the building. And certainly not everyone who testified in the case was a junkie, though several were. And certainly I would suggest unreasonable to infer that there was no one who was a law-abiding citizen who, because of their circumstances, found it necessary to live there. And certainly, again, I don't think you need to look at the red brief. These are admissions and acknowledgments that I make in my brief. Certainly, the jury would have been entitled to conclude that this was an illegal debt, if it was a debt at all.
But the judge instructed, didn't he, about the honest belief in some fashion? So
Here's what he said.
What's wrong with what he said?
Pardon me?
What's wrong with what he said?
Well, this is one sentence out of a 70-page series of instructions. There is no intent to steal if the defendant honestly and reasonably believes that the property is his. Clearly, and I acknowledge that there is...
Did the defense counsel come up afterwards and say that's no good?
Pardon me?
Was there an objection?
Did the defense counsel
he
say
did
that's...
not. He had proposed what I would consider a more appropriate instruction. And look, I mean, this is not the first time Your Honors and I have had this debate about jury instructions and implied burden shifting. And admittedly, I'm yet to persuade you that I'm correct. But to say if the defendant honestly and reasonably believes, I suggest very dramatically suggests a burden of proof that is placed on him. There's nothing by way of explanation which would tend to suggest this is a real issue in the case. Nothing that explains what is a reasonable belief. Nothing that suggests that this question of whether it was a legally enforceable debt was significant. And it truly turned out to be a fulcrum in the case. We can't know what happened in that hallway. The only clear evidence we have, notwithstanding the MO evidence, which is, of course, is significant, is what Mr. Vives himself said. And his explanation raised this issue. And I can only point the Court's attention to your own decisions addressing the question of the necessity to give an instruction of this sort. The name of the case escapes me now, but one involved a defendant who, according to the victim, kind of shows him a gun stuck into his waistband and says, I didn't like the fact that you testified against me. I want $100. And then when the victim says, gee, I don't think so, he said, well, then give me some collateral. And he takes his jewelry and various other things. Then when the defendant is arrested, he tells the police, the guy owed me money from a deal we had, unspecified deal, no question, maybe it was a drug deal, but that we had about a year ago. And this Court held ineffective assistance by counsel for having failed to ask the judge for an instruction on, and I would suggest it's certainly that in this set of circumstances, it's no more unreasonable than in that case that the instruction is important. And again, At the start of his instructions, at the end of his instructions, in his pre-instructions, the judge said the burden of proof is on the government. Okay? When he began talking about the elements of armed robbery, he mentions, hey, the government has a burden to prove the element of intent beyond a reasonable doubt. But then I don't want to suggest it's a throwaway line because that's unjust. But still, there's nothing to explain the significance of this pivotal point. And it would be so easy. And recognize, too, that while this Court now has a very clear and settled idea about what's an appropriate self-defense instruction, that it wasn't always that way. It wasn't always that clear that finding language was inappropriate. You only have to turn back the books 15 years to find those cases. And the same, I think, holds true as to self-defense, criminal responsibility, a number of other areas. It would be so easy to say, look, there is evidence in this case which raises this issue. It is therefore the government's burden to disprove or to prove three propositions. One, it wasn't a genuine belief. Two, even if it was genuine, it was not objectively reasonable. And three, it did not involve it involved an illegal debt, if any debt at all was owed. And that would remove any possibility that the jury could misunderstand what the government's burden of proof was and how significant this point is. And again, I would freely concede that the Court's sort of macro view of instructions, you have to look at them as a whole, and you certainly would look at the context of this particular element, is not incorrect. It's an entirely appropriate theory. Notwithstanding that, it's also important to note that as time has evolved, this Court has said, well, gee, you know, those general instructions are not enough to trump this error, whether it be Acevedo or Vizcarrondo or self-defense instructions or whatever it might be, and that the law is, after all, an evolving beast, and that in this context, there is some merit to what I say. And finally, I would note that the second and third arguments I raised, which pertain to inadequacies in the instructions with respect to malice, which is not before the Court, unless you were to conclude that I was right about the jury instruction. Because unlike a case where the case that we both cite is Commonwealth versus Roderick. It's a case from about 7 or 8 years ago. But in essence says, well, look, the jury clearly disbelieved the defendant's story about how this was not an attempted felony, and therefore we simply need not address all of these other questions. It's simply in terms of remedy, what would be the appropriate remedy, whether it be a retrial or a conviction for second-degree murder, that I point out that there are these potential deficiencies in the instructions on self-defense and on provocation. Though do note that the provocation instruction, one I ran up the flagpole before the Court just 7 or 8 months ago, and you were unpersuaded. Commonwealth versus Auer is the citation on that. And I guess finally concluding on a note of agreement, though one that accomplishes little for Mr. Vives, were the Court to be unpersuaded by the other arguments we have, it is necessary that the underlying felony, the armed robbery of Mr. Torres, be dismissed, and Judge Ford, trial prosecutor, and Ms. Lynch all agree with that proposition. So with that, Your Honors, thank you for your attention.
Thank you, Mr. Stevenson. Ms. Lynch?
Good morning. May it please the Court. My name is Bethany Lynch. I'm an Assistant District Attorney in Hampden County representing the Commonwealth. I want to start off first very quickly just reiterating what my brother counsel said as far as his fourth issue, the fact that the underlying felony
we've
merges.
got that.
Yeah,
We
that's
do agree
fine.
with that, and that we would rely on the Our case to deal with issue
Right.
number 3. As far as the honest and reasonable belief instruction, the defendant received the instruction. The majority of cases dealing with this issue are cases where a judge said that at trial he was not entitled and that he failed to give this instruction. In this case, it's the Commonwealth's position that he was not entitled to it, but the judge gave it to him
Judge gave it anyway, and
as
the
part of
judge
his
instructed
standard.
multiple times that the Commonwealth had to prove every element of the crime, one of which was intent.
Yes, he multiple times he instructed on that, including on exactly what specific intent was, on the element of that the Commonwealth must prove beyond a reasonable doubt that the defendant took the property belonging to another. All of these things were repeated, and the burden was almost hammered into the jurors. The number of times it was repeated that each element of all of the instructions had to be proved beyond a reasonable doubt by the Commonwealth, and that burden never shifted to the defendant. In this situation, he was entitled to the instruction that said that if he were to have an honest and reasonable belief that he was collecting a legitimate debt, then he would not have the specific intent to steal, therefore the jury must acquit.
But I'm sorry, I didn't see the word debt in the instruction. Maybe I'm wrong, I don't have the
I'm
complete-
sorry, that the property was his, I'm sorry.
Okay.
I'm sorry, I misspoke. As has already been read to you, the line of the instruction is that, quote, "There is no intent to steal if the defendant honestly and reasonably believes the property is his." That's exactly the instruction that this Court has set out as far back as White in the 1970s and straight through into the recent cases. The decision is whether or not the defendant is entitled to that instruction based on the evidence adduced at trial. In this trial, the only evidence of any kind of a debt, thus the defendant believing that the money was his, when viewed in the light most favorable to the defendant, as it must be in these situations, was him saying, "I saw a guy I knew, he used to deal for me, he owed me money." Earlier in the defendant's statement to police, he also said he had robbed a woman earlier, several days, actually I believe this was the day before, and he said the same thing. "I saw a woman come into the stairwell, she owed me money, she used to deal for me too, she didn't pay me all she owed." In terms of selling the drugs, he was a lot more explicit in terms of this other woman than he was in terms of the actual victim of the homicide. But I think it's reasonable to infer that this was not a legitimate debt, that these two people knew each other through illegal drug transactions. And the majority of the witnesses in this case were involved in drugs in some way or another. The victim, the woman who found the body, the person who gave the victim a ride to the apartment, almost all of the civilian witnesses were related to the drug trade in this building, and that seems to be what this building is known for in the city of Holyoke. So
your argument is, therefore, the judge needn't give the instruction anyway?
Right, the judge needn't have given the instruction.
Isn't that a question for the jury?
Well,
You're saying, well, they could have inferred that this was a drug debt. Yes, they could have, but that's really for the jury to decide. I mean, shouldn't the judge have given, if we're going down this road, shouldn't the judge have said something to the effect that if, in fact, the debt was for the sale of drugs, that would be an illegal debt, and that wouldn't be a debt that could be, legitimately collected in these circumstances? I mean,
I understand what you're saying, and I see where that could be a jury question, but I believe that the cases say that in order to get the instruction, it needs to be a legitimate debt.
and who has to prove that? Who has to prove that?
who.
Here, all we have is information it's a
I think
debt.
it's an assessment that the judge makes on the evidence in the light most favorable to the defendant, as it is in the.
But you don't give an
Abuse of
instruction
trust.
unless there's some evidence warranting it. And is there any evidence warranting the fact that this was a legal debt?
The only thing that could possibly warrant that it was legal debt would be the fact that he does not explicitly say that this money, he owed me money because of a drug transaction, or he had dealt for me in the past and didn't repay me, as he had said for the other victim. In this case, with this particular victim, the one who ended up being the victim of the homicide, he doesn't explicitly say that. I think there's more than enough evidence to be able to infer that from the defendant's entire statement, but it's not explicit. So if you require an explicit explanation as to the source of the debt, the amount of the debt, all of that before he would be entitled to this instruction, that hasn't been met in this case. But in terms of even looking at it in the best light of the defendant, you'd really have to kind of reach for that inference that it wasn't an illegal debt. And as far as that is concerned, because if it is an illegal debt, he was not entitled to the instruction in the first place, and therefore any problem that there may have been with the instruction did not prejudice him in any way, because he wasn't entitled to the instruction in the first place. The one thing I really wanted to focus on is that the jury instructions in this case, first of all, were exactly what the case law has told judges to do. If there is enough evidence, or if you perceive there is, this judge actually says that he tends to give it as part of his standard instructions, that if for some reason the jury were to find, based on the evidence, that there was an honest and reasonable belief that the property that the defendant has taken belongs to him, then there would be no intent to steal, and the defendant must be acquitted of the robbery charge. So the defendant got a very favorable instruction. I think it's reaching to say that this shifted the burden when the burden was so clearly placed on the Commonwealth throughout the entire trial. Throughout every instruction that the judge gave, the pre-trial instructions before the openings, he gave them in closings, and repeatedly in the closing charge to the jury.
Can I just go back to the legitimacy of the debt? Did the Commonwealth make an issue of the point?
No, the Commonwealth didn't raise it. This was just read into the record through the police officer. The defendant did argue it very briefly in his closing, but the defendant's defense in this case...
You mean the legitimacy of the debt?
No, he argued...
The legitimacy of the debt was not an issue in this case?
No.
Okay.
The debt itself was mentioned in passing in the closing. It was never really highlighted at any point, but it was mentioned. The focal point, or the focus of the defense in this case, was on intoxication and the defendant's ability to form the intent to commit any of the underlying felonies and thus the murder. And to a certain degree, the jury credited that defense because he was not convicted of deliberate premeditation. The defendant was convicted only of felony murder based on the armed robbery as the underlying offense, the armed robbery of Mr. Torres.
Are you familiar with the Gelpi case, Commonwealth versus Gelpi?
I am.
Okay. In that case, and I don't have it in front of me, but that's why I'm asking you. In that case, we said it was ineffective assistance for the lawyer not to request an instruction. So we wouldn't have said that unless the instruction would have necessarily been given had it been requested. So the evidence must have supported it.
Yes, the evidence supported
And was there evidence in that case that the debt was legitimate, where it was a debt owed because somebody testified against somebody else?
There was evidence that that the defendant demanded money of the victim because of a court case, is what the case said. Again, I don't have the record, so I don't know. But because of a court case, but then at the testimony at trial, there was testimony, I'm not sure who it was from, but there was evidence adduced that the debt was because of a deal about a year ago. That's all it said. And there was a...
So there's no obligation for the defendant to sort of demonstrate that it was a legitimate debt in order to get this instruction.
No, I would say that that would be something that the Commonwealth could have argued at trial, that it wasn't in order to avoid getting the instruction. In this case, the Commonwealth did not do that. And whether or not the instruction was needed or not, it was given. And I know that in the Gelpi case, the Commonwealth did argue at the appellate level that it was the result of an illegal drug transaction. That was the deal, was a drug deal, that apparently there was some money owed or something like that. But the court rejected that because it said that there was not sufficient evidence in the record that there was a drug connection between these two people, because all of the testimony apparently seemed to be very vague. So
if legitimacy of the debt becomes an issue, I take it it's an affirmative defense in the civil side. It's not part of a plaintiff's prima facie case. It's an affirmative defense. The Commonwealth would have to raise it, and it would be incumbent upon the Commonwealth to show that the debt was not legitimate.
I would say that if the Commonwealth were to challenge the debt, it would be.
And that was not an
There.
issue? The
No.
legitimacy was not an issue in this case?
No, it wasn't touched upon at
All right.
all. As I said, the only mention of it was in the defendant's statement, and that was just read. There was no questioning or anything. The defendant himself did not testify, as is his right. So there was no more than just this paragraph in the statement. And his main testimony was, I was looking out the window, I saw a guy I know, he used to deal for me, he owed me money. I think that's a legitimate or a reasonable inference to draw, that he owed money through their prior relationship. So in that case, it would not be a legitimate debt, and so he would not have been entitled to the instruction. Again, in this case, it doesn't really matter because the instruction was given anyway. And the sufficiency of that instruction, I believe, is at issue, and it's...
I don't mean to belabor this, but...
Certainly.
When you say that he's not entitled to the instruction if it's not a legitimate debt, but isn't that a jury question as to whether or not it's a legitimate debt? And wouldn't it be incumbent upon the Commonwealth to prove beyond a reasonable doubt that it was not a legitimate debt?
If it were an issue, then
So the defendant's always entitled to the instruction if there's some evidence of a debt.
I would say that in this case, that's what the trial judge believed.
Yeah.
The safer
Unless
route
the
would be to
Commonwealth
do that.
introduced
Unless-
evidence.
Exactly. Unless there's some reason that the Commonwealth, in this case, it was very overwhelming evidence against this defendant, and it was, I don't want to say it's unlikely the jury would believe, the jury could have believed, but
But isn't the short answer to this that nobody raised this point and he got the instruction?
he did get the instruction.
What else
And he
do
got
we
the
need to know?
instruction that he was entitled to.
Yeah.
Correct.
And that's our position on that issue. And that's really the only issue that I have to discuss. Unless the court has any further questions, I would just ask that 33 review be denied and that the defendant's conviction be affirmed. Thank you.
Thank you, Ms. Lynch.